Hi, this is Dana McLendon, host of the Ready for Trial podcast and the Ready for Trial social media content and vlog. You can check me out over here on any of these social networks where you'll see that artwork, or you can come find me on my law office website. Contact me through here. That'll have a phone number and whatnot that you can reach me. Today, I wanted to take a few minutes and go through the Marital Dissolution Agreement. As I said in a previous video, in Tennessee, there are two ways to get divorced. One way is to make a deal, and the other way is to fight about it. I'm going to cover today the actual document that is prepared in the event you are able to make a deal. This is just the Marital Dissolution Agreement, and I'm going to show you a sample form. I've redacted it to maintain the privacy of the clients, but this is the actual document that was filed with the court and approved by the judge. And it's got some elements in it that are useful to talk about. Some of these things may or may not apply to your case, but I picked one that had most everything that might to go through it. So let's take a look at that now. All right, so this is a sample final decree of divorce. This is what the judge actually checks out. In this case, these parties had a child as well. I will cover permanent parenting plans in another video, as well as go into some of the details of some of the elements of this marital dissolution agreement. But when you go see the judge with a deal that is reflected in a marital dissolution agreement, you will also present to the judge the final decree of divorce, and that's what this looks like. So as you see, the judge then says here, okay, here's the deal, and the paperwork is literally sandwiched in between. So the final decree comes in, and then the next document is the marital dissolution agreement. Now this is negotiated at some length, and in this case, this one took it took months of getting ready to go to mediation, and then all day at a mediation to get this deal done. So let's take a look at it. Some of this is what we call boilerplate, meaning it's going to read almost exactly the same in any given lawyer's version of the marital dissolution agreement. Certain facts are recited. You can see those here, that the complaint was filed on a certain date. And essentially what this says in a lot of expensive lawyer words is they've made a deal, and this is the deal. So, in this case, the husband was granted the divorce on the grounds of irreconcilable differences. It really doesn't make any difference. There is no concession of fault or anything here. When we say irreconcilable differences, we essentially mean that the parties have agreed to be divorced and that they are not blaming one another. They are simply agreeing to not be married anymore. In this case, there was one minor child. The rest of the story about the child is covered in a separate document called a permanent parenting plan. I will cover permanent parenting plans in another video. These parties own some real property, and in this case, the wife was awarded that real property. So that is what you see here in paragraph 3. Wife was given the real property. Paragraph 4, we cover vehicles. Somebody's got to get the vehicles. In this case, it would have been better if we had been able to put the VIN numbers in. We didn't have them at the time, and honestly, we were trying to get this deal done, so we didn't want to stop and delay things while people tried to get their VIN numbers. But if you have the VIN numbers in the document, then you will not need the other party's signature later when you go to get the title. So better practice would have been to put the VIN numbers in, but in this case, we knew that that wasn't a big issue because the parties each had their own vehicles in their own name. In this case, the parties had already split their property. That's really important because we were able to simply say, hey, these parties have already divided their stuff. The husband and the wife had not lived together for a long time, and we didn't have to argue about blenders. If the parties have not separated, or if they still have stuff, if they've separated but there's still stuff in someone's house that might belong to the other one, you can spend a lot of time trying to put together a list of the stuff in the other person's home that your client is going to go get. So just bear that in mind. I typically don't argue about blenders because my hourly rate is at least $300 an hour, and for $300 an hour, you can go to Target and buy almost anything before I can help you argue your way into recovering the blender. In this case, we also had to divide up some debt. There was some credit card debt. That's not at all uncommon these days. there's and that's all subject to negotiation. So you can see here that we divided up the debt, and we made sure that whoever accepted responsibility for that debt actually had to pay it, and if they didn't, the other one had a remedy, which was go back to the courthouse, get the credit card paid, and recover their money from the other side. There was also, in this case, it was a military pension. This investment and retirement account, paragraph 7, could just as easily be one or more 401ks or other kind of pension plan. In this case, the husband had a military pension, but paragraph 7 would be found in any marital dissolution agreement where the parties had had one or more retirement accounts or pensions or anything like that. Bank accounts, just like with debt, we have to divide up any cash that you may have in the bank. So that's covered here. Taxes, obviously, that can go a lot of different ways. If you are in a situation where there haven't been taxes paid in years, we got to cover that. If they have been paid, great. A lot of times we get people divorced, and then they have one more year to file jointly so that they can maximize their tax situation. So we cover how we're going to deal with whatever the tax situation is in a separate paragraph. Medical insurance, in this case, because of the husband's military benefits, the wife was going to be able to stay on his medical insurance even after the divorce. Most of the time, that's not true. If you live and work in the private sector, then you will not be able to provide health insurance benefits to your spouse after the divorce, nor will the other side be able to get them except through COBRA. And I've never seen a COBRA policy that was affordable or cheaper than getting back out on the market and finding it in the private market. Now, alimony, this was an important provision in this case. You'll see here that the husband in this case agreed to pay what is called alimony in futuro. I will do a separate video on the different types of alimony and what type of alimony may be appropriate in your case. But in this case, the husband was going to pay alimony to the wife, so we covered that in this paragraph. An alimony paragraph and a negotiation in alimony is one of the things that you most desperately need a good lawyer for. Whether you are the party asking for alimony or the party paying alimony, you will want to make sure that you understand what type of alimony and what are the circumstances that alimony might be modifiable later or in the future, or whether it's going to terminate on its own, or whether it's going to terminate or be subject to termination if you later remarry or even live with someone. So make sure when you get into an alimony conversation that you have a competent lawyer on your side. Life insurance, in this case we were dividing up the assets that were life insurance. Sometimes we also require someone to have life insurance, and you'll see that up here in the alimony provision, to jump back for a second. In this case, the husband also agreed to have $500,000 worth of life insurance to cover future alimony payments in the event that he passed away before he completed paying his alimony. In this case, each party agreed to pay their attorney's fees. Sometimes, depending upon the case, you might ask one party or the other to pay some or all of the attorney's fees that the other party incurred. Court costs, by this time, generally speaking, in any given case, there are either nominal or no court costs, but we do have to deal with them. Most of the time, those are paid up on the front end. Sometimes there's a little bit left over, depending upon how long you've been litigating and what kind of hearings you've had. Most of the rest of what comes next is what we call boilerplate, but it is nonetheless important because it's here and you're making it part of your deal. In this case, the parties had agreed to exchange informally some documents and information. There are processes in litigation and divorce where the parties can compel each other to give up phone records, bank records, credit card statements, that kind of tax returns, that kind of thing, so that you can investigate where the assets went or maybe what they were up to. That can be extremely expensive and very time consuming, and it is not always profitable, or it's not always a good idea to do it. Nonetheless, you have that opportunity if you want to do it. In this case, the parties didn't want to do all that. They pretty much knew what the story was as far as the money goes and who had done what. This is important. Paragraph 16, creditors. no matter what your deal is with your spouse, you cannot change the fact that you and or your spouse owe some other party money. So if you and your spouse have a credit card together to, say, Citibank, the fact that the husband might agree to pay the Citibank credit card after the divorce does not mean Citibank can't collect it from the wife. It just means that the wife will then be able to recover that money from the husband if she pays it. But you will not be able to change the deal that you have made with a bank or a credit card or any other creditor in your divorce. In paragraph 17, you'll see that there was a waiver of the answer. A lot of times this doesn't apply. In this case, the husband had not filed an answer because we were negotiating all along, and it just didn't need to be done. So to put a nice tidy end on it, we agreed that he was waiving his right to file an answer. Paragraph 18, tort claims. When you get divorced and you put a provision like this into your marital dissolution agreement, what that means is that you cannot go back and sue your ex-spouse for anything like assaulting you or giving you a venereal disease or upsetting you by having an affair or anything like that. When you sign a marital dissolution agreement and you put a tort claim waiver in it, that means you will not be suing them again for anything besides if they don't obey the terms of the deal. So general non-dischargeability, what this basically means, and the paragraph 19 and 20, essentially what this means is you can't agree to pay alimony and then go to bankruptcy court and get out of it. So if you have an obligation in a marital dissolution agreement to pay your ex-spouse, that is not going to be something you can bankrupt out of. Indemnification, complicated term. Basically what we're talking about here is you're going to do what you've said you've done in this agreement. And if you have to pay some debt that belongs to the other side, you can get that back from them. Enforcement, this is an important provision, and it's increasingly important. If you make a deal and go get divorced with a marital dissolution agreement, and then the other side reneges or doesn't do what they're supposed to do, you can not only sue them to make them obey or collect from them whatever they owe you, but you can now also get attorney's fees for having had to do it. And that's extremely important because judges, particularly where I practice, will absolutely award attorney's fees. They will put you where you should have been if the other side had just done what they were supposed to do. So when you negotiate a marital dissolution agreement, make sure that you get an attorney's fee provision in it in case you have to sue them later. Incorporation into the final decree seems obvious. If you're doing this deal and you're writing it down, this will be part of your final decree at the courthouse. Final settlement, lawyers like to say things 3, maybe 4 or 5 times. So the final settlement provision here provides that this is it. This is the whole deal. This is the only deal. And if it's not in here, then it's not a deal. It's not part of the deal. Paragraph 25, revocation of the beneficiary. This is really important. When you get divorced, and the minute that you're allowed to do so, you need to contact insurance companies, particularly life insurance companies and annuities, and let them know that you want to change your beneficiary, if in fact you want to change your beneficiary, and if in fact your deal allows you to. Make sure that you at least go look and make sure that whoever you've named as your beneficiary is who you would want to be your beneficiary the day after the divorce. I had to litigate that one time long ago, and there's some harsh results that happen because if you have a life insurance policy payable to your ex-spouse, even if you didn't mean to do that and even if you weren't required to do that, that life insurance policy is going to be payable to the ex-spouse, and that can really work some inequitable outcomes sometimes. Obviously, paragraph 26, binding. If you sign this and go to court and get it done, then it's done. You can't get out of this. Paragraph 27 and 28 and 29 and 30 essentially reduce to this. This is the deal. This is the whole deal. Anything you wanted to be part of the deal is written down here. You understand what you're doing here. And if for some reason a judge later says, well, I'm going to say that paragraph 14 is not enforceable, that doesn't mean that paragraphs 1 through 13 and 15 through 30 are not enforceable. So essentially, when you sign this, you understood what you were doing, and you meant to do it, and you knew everything you needed to know to do it, and you're stuck with it, even if a part of it is later determined to be unenforceable. Paragraph 31 commits both sides to sign any documents that might be necessary to sign later. For example, a car title. If somebody is awarded a car title that's not paid off yet, as soon as it's paid off, the other side has to sign it, for example. That's what this requires. Paragraph 32, if you want to change the deal after the fact, it can only be done in writing. Paragraph 33, obviously in Tennessee, if we're getting you divorced in Tennessee, we're going to agree that Tennessee law applies. Paragraph 34, if you end up having to enforce this agreement by going back to court to say, hey, judge, they haven't done what they were supposed to do, you can do that by motion. So that kind of creates a little bit of a shortcut for you. And then you see the signature provisions here with the notary public and all the formalities attached. So that's a sample marital dissolution agreement that covers a lot of the common areas of what we talk about in negotiations and mediations towards finalizing a divorce. If you have any questions, you can contact me here at danamclendonlaw.com. And I wish that you would also sign up and follow me on all these social media places, Twitter, Instagram, Spotify. I've got a podcast called Ready for Trial. I talk to other lawyers and judges about the things we do. So again, Dana McLendon. Look forward to doing some more videos to explain some more of what it is I do every day. Until then, thank you very much.